toxicology educator, Dr. Prashi Kaveri. So now we're having 21 days revision series where we'll be discussing the most important topics from forensic medicine. I hope this is going to help all of you medicos who are preparing for your prof exams. So without any delay, we'll get started. So firstly, coming to the important questions that we'll be discussing today, we'll be discussing about medical negligence. What are the ingredients of medical negligence? We'll also look at the defenses of a doctor in case of a medical negligence. And then the second 10 marker, the second long essay would be discuss professional negligence, difference between criminal and civil negligence, describe the legal principle of res ipsa loquitur. Now remember that res ipsa loquitur not only comes as a long essay, it can separately come as a 3 marker or your shorts. Now, coming to both of these 10 markers, you have to understand that both of these 10 markers are asking about medical negligence only. You have to understand what slight differences are there in the question and answer accordingly. And I'll be telling you exactly that. Coming to shorts, we'll be discussing about infamous conduct. We'll also see vicarious liability and also informed consent. Now, coming to what is Auricle? Auricle is a platform where you have recorded classes, live classes, practical sessions, exam module, as well as hard copy book set. So, help you prepare for your exams. Now, coming to the recorded classes, in recorded classes, we try to teach you everything from the beginning, no matter how small or big a topic is given equal importance. And here we build your concepts and we see to it that you master the subject thoroughly. It is going to offer you flexible learning as well as it is going to be very convenient for you to revise, because whenever you feel like you've forgotten something, you can go back and study it then and there. We also have live classes. In the live classes, we are going to discuss the important questions, especially those that have been asked as PYQs in your previous 10 years. And why this question is important? Because these are the things that will be most anticipated, and before going to an exam, you cannot miss on these. And these are going to be interactive sessions where there will be doubt clearance, MCQ polls, and so on to keep you engaged. We also have express exam module here. Every subject is going to be completed in less than 20 hours. That means we'll be focusing only on the very important topics that you have to focus just before going and giving your exams. We'll also tell you what diagrams to put, what flowcharts to put, and we're going to give you an effective answer writing skill. There's also one-to-one doubt clearing session where a student-centric approach is taken. And here we focus on the student's doubt. A personalized attention is given to all the small and big doubts that the student has. It is going to be a safe learning environment where the students, without being scared of being judged, can study and finish. We also have hard copy note set, and these hard copy notes set are going to give you in-depth coverage of the topic. There are images, there are going to be flowcharts, and all which are going to help you in preparing for your exams. We also have QBank, and the QBank of Auricle has 3 levels. We have the beginner level and it goes up to the expert level, and it is a customizable QBank. That is a very good thing about Auricle QBank. Whichever topic you're studying from, you can choose questions from the same QBank and you can solve, so that it will be a active recall of the passive studies that you have done, so that it is going to help you remember things for a longer amount of time. We also have practical classes. Here in the practical sessions, we're going to give you hands-on experience, and we're going to engage you in interactive sessions that is going to simulate real case scenarios, and here also give you information about Viva OC as well as what spotters can be kept. So once you know all these, you're going to master your practical exams. Coming to the subscription plans, we have the foundation plan, advanced learning plan, complete learning plan, as well as the ultimate MBBS plan. So we have all these plans that are giving you various benefits from Auricle. So make use of all these plans. Now, coming to the topic per se, today in the revision class, we'll be discussing about medical law and ethics. We'll be discussing the top-notch questions that will come from here, and also I'll be telling you about how you need to answer the question. In the first question, they're asking you about medical negligence. Want the definition of the medical negligence first, and then they're going to ask you the ingredients of the medical negligence, defenses for the doctor in alleged medical negligence cases. So understand the question first. They're asking you about medical negligence, and they're to tell in depth the elements of the ingredients of the medical negligence. So that is the second part. Okay, so here both of these would carry 3 marks, and later there is a final part of the question which would carry 4 marks. This can be 4-3-3 or 3-4-3, but remember, this is going to be a rough idea of how the question is divided. And let's see how you have to answer it. First, you write about what you understand by medical negligence. That is, you're going to give the definition. So medical negligence means there is absence of a reasonable care and skill or willful negligence of a medical practitioner in treatment of a patient which causes his bodily injury or death. That means either the doctor doesn't have very good skills to treat a patient that he had to have. Usually after a person finishes MBBS, he is supposed to have a particular level of skill set. Maybe the doctor doesn't have it, or he willfully does a foul play. He willfully neglects. He just feels like it's okay, I don't have to do all these. And he, kind of willfully does a negligence. So these are the cases where there will be medical negligence. So coming to what are the ingredients or elements of medical negligence. Firstly, there are so many D's, okay? Remember D4. Or the 4 D's that you have to mention whenever they ask about ingredients. So whenever you write here, a lot of time what happens, you'll not have time to revise everything. That time you have to revise important things. So whenever you're studying this question for the elements, the ingredients part, you write D4 and keep. So whenever you're in the exam hall in that stress, at least if you remember D, you can think and answer what it is. Firstly, write about duty. So what do you understand by duty? As I told you, after you have finished your MBBS, you have the duty to serve people, and you are supposed to have a specific kind of skill set or a specific kind of approach to the patients, where you need to have that basic knowledge to treat the diseases, or that basic knowledge to refer to higher doctors when you know that you can't serve the patient. Next, we have dereliction. What is dereliction? Failure on the part of the doctor to maintain applicable standard of care. That is, it is his problem. He is not able to give a proper care to the patient. Then, direct causation. Negligence can happen because of a negligent act. That means he has done an act, and that act directly caused to the death or a harm to the patient. Then we have damage. That is type that could be foreseen by a reasonable physician. That means what they are telling you here is, for example, if a person has come to you after a fall, or after he's pricked by a iron nail which is rusted, then common sense as an MBBS doctor is to give him a TT injection. Now imagine you have not done it. That is a basic thing each and every doctor has to do. No, he has not done something which is very basic, and that has caused damage to the patient. Okay, so these 4 other D's that you have to remember. Now, whenever there is a medical negligence, who has to prove it? Patient should always prove it. This is even in your Viva OC, they can ask it. Whenever there are any damages, the patient done. So remember that there has to be a damage which can be, so that the patient can come and sue the doctor. But if there's no damage, he cannot simply say that I'm not feeling well, maybe it was a doctor's fault. No, he can't do it. There should be a damage that is seen. Loss which can be measured or compensated in terms of money. So remember, there should be a damage or a loss which in the court they can see and properly say that it has to be compensated because it was a doctor's mistake. Now let us see a few examples where a medical negligence can happen. Refusal to admit the patient requiring urgent hospitalization. Imagine somebody has come to you after vomiting or after 7 to 8 loose stools in a day, and know that you have to give him IV fluids and admit the patient. But if you fail to do it, failure to obtain informed consent, that is, you have not taken consent from the person. Failure to examine the patient, that is, whenever a patient comes to you and has some problem, you have to always examine the patient. You have to do all the basic examination, RS, CVS, CNS. Now, if you fail to do that, failure to perform sensitivity testing. For example, whenever you give an injection of lignocaine, you have to always do a sensitivity testing in order to find out whether the person is sensitive. You have to do that small test. If you, in your internship, you learn whenever you're going to do dressings, you have to give a small injection on the forearm. It is a injection to test the sensitivity. And then not ordering X-ray. Like if you suspect a fracture, that is, the patient comes with a lot of pain, he's not able to move his limbs. Even then, if you don't, order an X-ray, or if there's an X-ray, you're not able to read it. As an MBBS doctor, you're supposed to read it. So these are all the various instances which account for negligence. At least 4 to 5 of these should be mentioned in your paper so that you get that marks. Now, what are the differences for doctor? If there is an error of judgment, if he has secured all necessary data. Now imagine he has asked all the questions, he has done all the examination of the patient, and then after he has got all the results, he fails to come to a conclusion of what the problem is, because he has done everything in his part and he missed something little. There was a small error, then it is a defense for the doctor. Failure to cure or bad results if he has experienced reasonable care and skill. That is the second point. That is, the doctor has done everything to give proper care to the person. He has given proper treatment. Even then, the patient did not respond well. He got a bad result. Maybe he died or his condition did not improve. Now, doctor, can he be in the fault? No, he's not at fault, because from his knowledge or as a basic common sense, he has done everything that he knew to save the patient. So he won't be guilty here. And another instance that you can write here is he has ordered all the proper examinations. He's ordered all the tests. Even then, after getting all the results, if the tests were negative, and then he could not get an answer. Like, for example, there is fever of unknown origin. Okay, this is something that you'll be studying in your final year, and it is one of the important 10 marker. Okay, that is after so many investigations, after being admitted in the hospital also for 3-4 days, you're not able to tell what is the cause of the fever. Now, in such a case where you have done all the investigations from your part, if you're not able to cure that person, you want to be necessary, because you have done everything that you could do. There's something called as doctrine of common knowledge. That is, negligence in the particular case is not related to medical profession. To always understand that, firstly, you have to use your medical knowledge in a good way to save the patient. And if you have done everything in your skills, or you have done everything that any other reasonable medical doctor would do, then you're not responsible. There's something called as composite negligence. What is composite negligence? Injury due to negligent act of more than one person. Composite, simple. Composite means more than one. That's a complex thing, because whenever there's negligence by more than one person, it is called as composite negligence. In the question, they're not asked you about this, okay? But if you mention this, you always have a extra chance to get 1 or 2 extra marks. That's why I've mentioned this. In every question, I'll be mentioning 1 or 2 points that, in case you have time, you read upon it and write, you can get extra marks. Same for this slide also. Medical maloccurrence. In some cases, in spite of good medical attention, there can be some problem. The patient may not respond. Then also, you are not responsible. Novus actus interveniens. What is it? Person is responsible not only for his actions, but also the logical consequences of his actions. That is, imagine the doctor tries to do something. In that process, he is going to do some more action, and the thing that those actions would have caused damage to the person. Maybe he directly is not responsible for the damage, but the consequence of certain actions of his caused the damage. Even that is called as novus actus interveniens. That is a new act which occurred because of something that the doctor did has caused the damage. So I'm putting, as I told you, these are the things that you can mention and get extra marks. Also, these are the things that will come in your Viva OC. Okay, so pay attention. What is contributory negligence? That is unreasonable conduct or absence of ordinary care on the part of the patient, which combined with the doctor's negligence contributed to the injury. That is, the patient also contributed to the negligence. So the doctor did something which was negligent, plus the patient also did some action which contributed to the doctor's negligence. Therefore, it is called as contributory negligence, and the patient's condition worsens. Example, failure to give doctor adequate. If the patient hides something, he's not telling doctor properly. That is, from the patient's part, it is wrong. It can contribute to the negligence of the doctor. Refusal to take suggested treatment or refusal to take tablets, skipping tablets. So the patient is doing wrong, which will contribute to the negligence from the doctor's side. Coming to the next question, discuss professional negligence, differences between criminal and civil negligence, describe the legal principles of res ipsa loquitur. So remember that professional negligence is nothing but negligence only, okay? Being a medical professional, if he does a negligence, that is called as professional negligence. Now, you have to also differentiate between criminal and civil negligence. This is what we did not discuss in the above question, and I'll be focusing more on that in this question. And also, we have to know about res ipsa loquitur. Now, coming to the professional negligence, absence of the reasonable care or skill or willful negligence of a medical practitioner in treatment of a patient. So, as I told you, it is nothing but you're talking about medical negligence. The doctor doesn't have proper skill, and that caused damage to the patient. Now, coming to civil negligence. What is civil negligence? Patient, or in the case of death, relative getting compensation from the doctor, or from the doctor's side, relative. See, civil means you have to understand that court is involved. Why does a patient or a doctor go to the court? A doctor goes to the court when his fee is not received by the patient, and the patient goes to the court, or his relative goes to the court because he feels like doctor did something and his kid, his relative died, and now they want compensation from the doctor. So these are the instances when one of the person, either the patient or a doctor, can go to court. What are the elements of negligence here? Same thing as I discussed in the previous question. Duty. Doctor has a duty to save patient. Dereliction. He goes away from something that he has to do. Like there is a standard care that he had to give to the patient. He went away from it. Direct causation. He does an act which will directly cause injury to the patient. Damage. The act can do a damage, and the damage is clearly seen. And if he was a skillful physician, he could have foreseen that his action could have caused damage. So this is the same thing that you have to write for professional negligence, civil negligence, or criminal negligence, or even medical negligence. So this is the same thing, which is the essence or the element of all the types of negligence. And as I told you, burden of proof is always on the patient, and there should be damage, which is that there is a medical negligence that's happened. Now, coming to the liability, the amount of damage done. Now, see, when we talk about liability in cases of civil, the amount of damage done as a measure of extensive liability. Example, what all can be charged for? Expenses, including medical rehabilitation, transportation, additional surgical procedure. So you might go to the court and say that this doctor did not give us proper instruction, because of which we did so many tests, we did so many, surgical procedures. Those were unnecessary. To and fro travel expenses. So you're going to charge all these. The patient is going to charge all these in the court of law. And then he might also say that he has lost his, as well as he has suffered pain and suffering. What are the instances? As I told you in the previous question, same other instance: a refusal to admit patient who requires hospitalization, failure to examine a patient, failure to perform a sensitivity testing, failure to order an x-ray and not reading x-ray correctly. Like for example, if it's a left leg and you say it is a right leg, and if you unnecessarily delay the diagnosis. So these are the various instances. Some more example: giving wrong diagnosis to provide substitute during absence. That is, if you are not there, you're not giving a junior doctor or some other substitute doctor. Failure to warn patients of the side effects, experimenting on the patient without consent, giving overdose of medicines, and failure to give proper instructions. So these are very simple ones. I suggest you to remember the first 6 of these, which you can add in both the questions. Okay, these are important. If a doctor is not liable, as I told you, has done all the tests that is possible, all the investigations, even then if something goes wrong, he is not responsible, because he has done everything in his power. And when he has done all the treatment, if the patient does not respond, even then he is not going to be responsible. Now, coming to how this civil negligence is different from a criminal negligence. So criminal negligence occurs when the doctor shows gross absence of skill. The word suggests it's criminal. No, criminal means it has caused death of the person, because the doctor doesn't know anything about his job. Only then he can be called as a criminal. Doctor performs some illegal act, like for example, illegal abortion. It involves an extreme departure from the ordinary standard of care. That is, anybody, as I told you, who has finished MBBS should have a reasonable skill set or a mindset to treat a patient. If he goes very much away from it and does something which, like a criminal person, like without any care for the patient, then it comes under criminal negligence. Practically limited to which the patient has died. As I told you, then only the doctor is called as criminal, because the patient of a wrong finger or a limb. Like for example, anybody who has if there is a problem in the left leg, they go and operate in the left leg. For example, if you do not do that and cut the opposite leg, that is a gross mistake from the doctor's side, which comes under criminal negligence. Leaving instruments in the abdomen, performing criminal abortions, as I told you, gross mismanagement of delivery. Like as I told you, there are different stages of delivery: stage 1, stage 2, stage 3, stage 4. So initially there is dilatation of the cervix, then the baby comes, then you remove the placenta, then it is the phase where you observe the lady. Now, when you remove the placenta, you have to remove it in a particular manner. Okay, so if you fail to do it and suddenly pull it off, and then if the uterus involutes, so these are the cases when you are charged under a criminal negligence. When there is gross absence of skill, it is so bad. It's such a bad, pathetic situation to be in. Now, coming to the short answers, we have first one: infamous conduct. So what do you understand by infamous conduct? Number 1, medical malpractice. So it is the short answer. So you have to write 4 to 5 points about it, and that is enough. Instances where doctors fail to provide standard care, leading to harm or injury, can result in lawsuits and loss of a license. Okay, so one is when the doctor doesn't do his work properly. Then we have under infamous conduct, fraudulent practice. What do you understand by fraudulent practice? Some doctors engaged in fraudulent activities such as falsifying patient records. That is, they are willfully doing something wrong. There is no moral or the ethics that the doctor follows. Then it is called as a fraudulent practice. Overbilling insurance in order to get extra benefits for the doctor, or performing unnecessary procedures for the case of profit, or performing unnecessary investigations. So these are all coming under infamous conduct where the doctor's moral and responsibilities is forgotten. Next, if the doctor asks the patient sexual misconduct, emotional abuse, or exploitation of vulnerable patient. So all these comes under abuse. So the doctor uses his power in order to sexually misconduct or emotionally, abuse the patients. Then substance use in doctors. Physicians struggling with the addiction may endanger patient safety. You have seen this movie. I hope you've seen this movie of Arjun Reddy, no? So in this movie of Arjun Reddy, at a point when he was very low after his girlfriend left him, he started drinking, and then he would come and operate after being drunk, and that is how a lawsuit was filed against him, and then he was barred from practicing for a while. No, so this is what happens if a doctor treats the patient whenever he is in that high. Violation of ethical standards, research misconduct such as falsifying data or not obtaining informed consent. Remember, one of the legal duties of a doctor or a medical jurisprudence is to obtain consent for any procedure or an operation or any investigation. They have to obtain consent. If we fail to do all these, then we can be filed a lawsuit against. Got it? So remember, whenever the question of what is a question, infamous conduct is asked, remember all these things and write it in the form of points, and always give this side heading so that you get that extra marks. Medical malpractice, next is fraudulent practice, abuse of patients, substance abuse, and violation of ethical standards. Coming to the next question, vicarious liability. What do you understand by vicarious liability? Employer is responsible not only for his own negligence, but also for the negligence of his employees. That is, let the master answer, or let the superior answer. What do you understand by this? That is, imagine I am running a hospital and I'm the senior most doctor in my hospital. So I will not only be responsible for the mistakes that I do or the negligent act that I do, but I'll also be responsible for all the negligent act that my employees or all the junior doctors that I have hired. No, if they do any negligence, then I'll also be responsible for that. In simple words, this is how you have to understand vicarious liability. Okay, it is also called as let the master answer. What are the examples? Principal doctor responsible for negligence of assistant. This is the same example that I gave you now. So for the question of vicarious liability, you can write examples by using your common sense only. Once you read all these examples, it is going to stay in your brain. If you just go and think in the exam hall, you're going to remember. Remember, forensic medicine and toxicology is 90% common sense only and 10% what is there in your books. Okay. Borrowed servant doctrine. That is, if I borrow some other doctors for my work because I have borrowed, I'll also be responsible if they do some negligence. A hospital as an employer is responsible for negligence of the employees. That is, a hospital, the entire body is responsible for all his employees' negligence. Coming to the other examples, hospital management is responsible for the mistakes of the residents or mistake. The hospital management is responsible even for that. If the physician has written prescription properly, this is something that you have to remember. He's not responsible if the pharmacist doesn't read his prescription well, or if pharmacist does any negligence. Prescription properly, doctor is not necessary. When the doctor recommends another doctor, he is not liable for the that doctor because he has already recommended and sent the patient to the other doctor. So these are the examples, and as you can see, these examples are very much like common sense examples. If you just think about it, you can write. But remember, whenever a 3-marker is given, always put side headings, because when these side headings are what is going to fetch you marks rather than your content for 3 markers. Okay. Coming to the last question, informed consent. So what is consent? Consent is nothing but agreement or permission which is legally valid. That is, a doctor says the patient do this procedure or an operation or this investigation, or patient is going to give a consent or permission to do it, and this consent is going to be owned by law. It is going to be legally valid. after understanding what it is given for and the risk involved. See, it is called, consent means giving permission. Now, what is informed? Informed means the doctor is going to tell everything to the patient about what happens after the procedure, what are the side effects, what are the risks, what are the plus, what are the minus. After understanding everything, then if the patient gives consent, it is called as informed consent. Okay. So the patient has to understand, number one, nature of the condition. So what is he suffering from properly? Nature of the proposed treatment or the procedure. He's understanding everything about whatever treatment the doctor is suggesting to him or whatever procedure the doctor suggests to him. Then we have expectations of the treatment and likelihood of success. That is, any treatment will not give you 100% success. No, some it will be 50%, some it will be 90%. Even that has to be informed to the patient. We have to always inform what are the alternative approaches. Now, for example, if there is a fibroid in the uterus, you can undergo myomectomy, you can undergo hysterectomy, you can give tablets, you can give so many things can be done. You can even insert Mirena. So there are various options. So you're telling about all these options to the patient, and also you're going to explain about what are the risks that are there if you do not undergo the procedure, and also you're going to tell what are the relative chances of success or failure. So once you inform all these, if you get a consent, it is called as informed consent. So according to me, the three important questions from whatever we discussed, one is the medical negligence. So you have to study medical negligence as a whole, okay, so that you'll be able to answer any 10 marker or a 5 marker or a 3 marker that can come from it. And secondly, informed consent is very important. Vicarious liability is very important. So focus on these three things. And as I told you, there are not many images that you can put in this chapter. There are not many flowcharts. Okay. So in this chapter, whenever a question is asked, always focus on putting a proper side heading and write about it and underline the important points that you write. Okay. Got it. I hope you enjoyed this class. I'll be coming up with so many other chapters in the same form where we'll be discussing the most important topics. Thank you.